Thank you, Lee. Liabilities. We've hinted at it all day. If you screw up as a trustee, you can be held personally liable for that. It could be that there's debts unpaid. I mean, if you distribute all the assets out of an estate or trust and did not pay the debts that were properly due, then those people could come after you individually. Now, you can go after the beneficiaries to collect it back, but if they've already spent it, then you're in hot water. That even includes unpaid taxes. If the estate owed taxes and you're the executor and you didn't file the tax return, you didn't pay them, then the IRS can come after you as the fiduciary to pay those. You can be held accountable if you have a breach of trust or a duty under the trust. Could be that you failed to do something you were supposed to do, or you did something you were supposed to do poorly. Your job as trustee is to follow the rules of the trust. The trust itself is kind of like your monopoly rules. You've got to follow them, or you can be held accountable. If there are court orders, if you're ordered to do something and you fail to do so, you can find yourself in contempt of court. If there are losses in the trust, you may or may not have liability, depending on whether or not you've met your duties. If you've met that prudent investor rule, then you're not held personally accountable if the assets lose value. If you do not meet that standard and they lose value, then you can be held accountable. If you delegate authority, which you can do some delegation, but if you put all the investment authority over in the hands of an investment advisor, you're still the trustee. You're still the one responsible for the investments. And a big no-no is commingling assets. I mean, you're holding someone else's stuff for the benefit of someone else. You don't want to borrow from that trust. You don't want to mix those assets with your own assets. All these things can create personal liability for you. There can be losses due to delay. You were going to sell that house, but it burned down before you got around to it. You were going to sell that block of stock, but it lost its value before you could get around to diversifying. You were going to file that annual accounting you were supposed to file, but never got around to it. So now we've got to hire someone to clean up the accounting work. All those extra expenses can become your personal expenses. If there's a house in your trust and you have to have work done to it, say a new roof needs to be put on the house. When you hire that contractor and sign the contract to put the new roof on the house, you want to make sure you're signing it in the capacity as a trustee. Because if you just sign your own name without any indication that it's the trust that's hiring them, that contractor could then go after you personally to get their bill paid. With all the risk of liability, in fact, I thought of one little quick joke. Some clients once asked me, which of my kids do you think I should pick to be executor? I said, which one are you mad at? So what if you don't want to serve? I mean, nobody can force you to serve as a trustee or executor. You can always choose to not accept the role. If you have accepted it and don't want to continue, there are options to resign. The trust may offer options to resign and appoint someone else. There's often the ability to even appoint a co-trustee. A co-trustee is someone you can actually delegate authority to and be shielded from some liability. And you can always hire help. Go to CPAs, go to attorneys, go to financial advisors, and get advice to help you through the process. Yes?
Excuse me, is there a limit of years that somebody can come back or the government can come back to collect taxes, or something is owed you didn't know about? Is there a term of years when they can no longer come back and collect?
Essentially the question is there a cutoff date when a creditor or the government can come after taxes? And the answer is yes, but it's different for all kinds of different things. Taxes in particular, the IRS has 10 years to collect a tax. If there's a judgment out there, a judgment lasts for 10 years and can be renewed for another 10 years. If a creditor hasn't reduced their stuff to a judgment, if it's a creditor of the trust itself, the typical statute of limitations is about 3 years. If it's the decedent's debts from prior to death, you can file that 90-day notice to creditors and cut the time limit to 90 days. And if you don't, it's typically 2 years, but again, there's different statutes for different items. Yes?
In many of these cases where the trustee is liable, who would typically file a complaint?
All right, now the question is, who would actually seek to hold the trustee liable? Beneficiaries. If you're a trustee of the trust and the beneficiaries are the decedent's kids, and you don't meet your standards and losses occur, they're the ones unhappy because they have the loss, and they're the ones that sue you. Yes?
Same would also apply if your beneficiary is a organization or a charity that you've left money to.
Yes, yes. Whoever the question is, even if that's a charity or some other organization that's a beneficiary. The beneficiary has those rights, and the beneficiary could come after you.
If you have specified who gets what and how much, they wouldn't have a leg to stand on. Would that be correct?
The question is, if you have specified who gets what and how much, do they have a right to sue? But that's slightly a different question. Say you've got 3 kids and you've disinherited all 3 of them, and they want to contest your will. That's a will contest that says, yeah, Mom should have left this to me, she must have been crazy, let's throw this will out and give the stuff to me. And often your will or trust will have a clause in it that says if anyone contests, they're treated as predeceased. That's different than they already are a beneficiary, and on the trustee's watch, a loss occurred. Does that answer your question?
If it didn't, I'll raise my hand.
Okay, good. Any other questions? Yes?
If I'm a successor trustee and I decide that I need some consultation help from a lawyer, I assume, and I'm asking for verification of my assumption, that the trust pays the lawyer's fees for that consultation as opposed to me?
The question is, if you as trustee are hiring a lawyer, who's responsible for the fees? You as trustee or the trust? The answer is it depends on why you're hiring the lawyer. If you're hiring a lawyer to defend your own bad actions, it's going to be your own expense. If you're hiring a lawyer to help with the assistance and proper administration of the trust, that is a trust expense. All right, any other questions? All right. What you don't want to do is do the job poorly. Lee, would you like to talk about some resources?